Attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about the federal and Florida M&A broker exemption. Following the SEC's lead, effective July 1, 2016, Florida passed a statutory exemption from the broker-dealer registration requirements for entities affecting securities transactions in connection with the sale of equity control of private operating businesses, called an M&A broker. Like the federal rule, the Florida M&A broker exemption sets forth certain limitations and restrictions related to the ability to use the exemption. In particular, M&A brokers cannot have custody, control, or possession of, or otherwise handle funds or securities issued or exchanged in connection with an M&A transaction. M&A brokers cannot engage in any public offering of securities which is registered or required to be registered under the federal or state securities laws, or in a transaction that will result in the company being required to file reports under the Securities Exchange Act. No party to the transaction can be a public shell company as defined by the Florida statute. The M&A broker cannot be subject to certain bad actor disqualifications. In particular, they cannot be barred from association with a broker-dealer by the SEC, any state, or any self-regulatory organization, be suspended from association with a broker-dealer, be subject to any federal order censoring or placing limitations on the person related to acting as or being associated with a broker or dealer, be subject to the disqualifications under either Rule 506 or Regulation A, or be subject to any final order of a state securities commission or agency barring association or activity with any bank, savings or loan, or credit union. Prior to completion of the transaction, the M&A broker must obtain written assurances from the control persons with the largest percentage ownership of both the buyer and seller that after the transaction is complete, the buyer, acting alone or with others, will be a control person of the acquired company or of the business conducted with the assets of the acquired company. And prior to completion of the transaction, the M&A broker must obtain written assurances from the control persons with the largest percentage ownership of both the buyer and seller that if the transaction involves the offer of securities in exchange for securities or assets, the person receiving securities will receive certain disclosures, including the most recent year-end financial statements of the issuer of the securities prepared by the issuer in the normal course of business. These financial statements need not be audited or reviewed, though if an audit or review is available, it must be provided. The person must also receive a balance sheet dated not more than 120 days before the date of the offer or exchange of securities, and finally, information pertaining to the management, business, results of operations, and material loss contingencies. The Florida statute defines a control person as an individual or entity that possesses the power, directly or indirectly, to direct the management or policies of a company through ownership of securities, by contract or otherwise. A person is presumed to be a control person of a company if, with respect to a particular company, that person is a director, a general partner, a member, or a manager of a limited liability company, or is an officer who exercises executive responsibility or has a similar status or function, has the power to vote 20% or more of a class of voting securities, or has the power to sell or direct the sale of 20% or more of a class of voting securities, or, in the case of a partnership or limited liability company, may receive upon dissolution or has contributed 20% or more of the capital. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.